A Missouri teacher received an absolutely mind-blowing sentence after she was accused of sending explicit photos to a 16-year-old student. Charged with crimes as serious as statutory rape and child sex trafficking, it seems Rikki Lynn Laughlin got off easy. How did this happen? I'm going to break it down, and we're going to speak with a sheriff with over 30 years of experience who offers stunning insight into these particular cases. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. This one is going to shock you, okay? A married Missouri special education teacher has actually managed to avoid prison time after admitting to sending explicit photos and videos to a 16-year-old student. And though far more serious charges, including statutory rape and sex trafficking of a child, they were dropped in this plea deal. 26-year-old teacher Rikki Lynn Laughlin pleaded guilty on July 24th to a single felony count of first-degree endangering the welfare of a child, specifically for creating a substantial risk to the teen's well-being. Now, the charge carried no sexual conduct designation, allowing her to walk away with, get this, 5 years of probation instead of any jail time. Now, this might be what ultimately ended up playing out in her sentencing, but court documents reveal allegations of a much darker story that we need to talk about. So Laughlin was a teacher at St. James High School in St. James, Missouri. That's about 75 miles southwest of St. Louis. And this is when the illicit exchanges began in September of 2023. According to a probable cause statement from the Marys County Sheriff's Office, a teacher identified as Laughlin started communicating with a student over Snapchat, a connection that, in the student's words, progressed fast. Now, the student told investigators that after initial contact, the relationship quickly turned inappropriate. He said he and Laughlin even kissed inside a classroom at school. Now, here's what the student told police, according to the probable cause statement from the investigating officer. The officer met with the student on October 20th, 2023, just one day after allegations of Laughlin's inappropriate behavior came to the attention of the sheriff's office. And during that interview, the student described how the relationship began and how quickly it escalated. The officer wrote, "During the interview, the student did disclose to me Laughlin had reached out to him on Snapchat and things progressed fast. The student stated that they even kissed while in the classroom of the school. As detailed further in the statement, Laughlin reportedly expressed a desire to have sex with the student and invited him to her home when her husband was away." The officer wrote, "The student informed me that during his conversations with Laughlin, she stated she wanted to have sexual intercourse with him, going as far as to invite the student to her house on October 14th, 2023, because her husband was not home." Now, investigators noted that the student also claimed Laughlin requested sexually explicit photos from him, and he complied. Now, fair warning here, this is quite graphic. So the officer noted in the report, the student stated Laughlin asked him for photos of his genitals, and he did send 2 photographs to her via Snapchat after he got out of the shower. This was done on 2 separate occasions. The student stated Laughlin did acknowledge receipt of the child's sexual assault material photographs. By the way, talking about the law, there is a reason that Morgan & Morgan, our sponsor, is America's largest injury law firm. They're a firm with over 1,000 attorneys. You know why? Because they win a lot. They have recovered over $25 billion for more than 500,000 clients. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. Out in Pennsylvania, a client was awarded $26 million. That is 40 times the insurer's $650,000 offer. Another client in Pennsylvania received $29 million after being offered only $500,000. And even if you think your case isn't worth millions of dollars, why not start a claim and fight for what you deserve? Morgan & Morgan makes it so simple. You can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar or scan the QR code on screen. Now, as rumors of their communication began to circulate at school, the student then told police that Laughlin had urged him to hide the evidence. The statement from police reads, "The student informed me that Laughlin did tell him to delete the videos and photographs from his phone because people at school were talking about them being in contact on Snapchat." He also claimed that Laughlin was aware of the legal risks involved. The officer writes, "The student did tell me that one of the conversations Laughlin and he had was Laughlin telling him she could get jail time for doing what she was doing." Now, unfortunately for Laughlin, the student didn't delete all the images. And I'm going to explain what happened next. But first, I want to bring on a special guest to help break all of this down, somebody who's very familiar with these kinds of cases, helps to catch child predators. Genesee County Sheriff Chris Swanson. Chris, thank you so much for coming back here on Sidebar. I mean, you have seen a lot in your very long time of service. What was your reaction when you heard that a teacher admitted to sending explicit material to a minor and still avoided prison time?
That part is unusual, but the teacher-student predator-prey behavior, we see that, and we've talked about it on this show, Jesse. But the 5-year probation, this is why plea deals have so many different layers.
Yeah, and I'll get into what she was charged with. It just seems to me there's obviously always an incentive to make sure not to go to trial, right? You don't want to go through the time and expense of a trial. You don't want to have to put the alleged victim on the stand. I get it. But at the same point, what is this saying? What is the message of 5 years probation considering what she was ultimately facing? That's the challenge. And I want to talk about it a little bit later when we get into the charges. But from an investigative standpoint, what are the most challenging aspects when you deal with cases involving educators and students, especially with social media apps like Snapchat involved?
So that whole relationship, the teacher-student, is very complicated because there's so many times where those teachers are with those students alone. These many times happen over months and even sometimes years. And then you have somebody that uses social media, whether it's Snapchat, Instagram, or TikTok, or other, sources. Many times in our investigations, we'll take them offline and go onto a chat app, and there's thousands of those. So as an investigative part, we may only uncover one piece of evidence, but there could have been so many other conversations and other videos and photographs that are shared on chat apps that we don't have, that have either been deleted. And again, in law enforcement, not everybody has those same forensic download tools that big agencies have. So it's important that wherever you're doing these investigations, that you tap into the phone. That is the most critical piece of evidence in any of these investigations.
Aside from the videos and the material that might be saved on an actual digital device, retrieving records, maybe things that were deleted, especially if you're talking about Snapchat, is it tough to retrieve those records from a law enforcement perspective?
It's not for the tools that we have, but for those that don't have those tools, that's where the obstacle comes in. But, forensic downloads of phones, this right here, this is the new creepy white van that we've talked about from the 60s, 70s, and 80s. Your phone, even if these files are deleted, they are built into that phone. The other challenge is some of these apps that we have to go get search warrants for, they're not always user-friendly. They don't want to work with law enforcement as much as others do. And so when you send a search warrant and you're asking for records, there's a lot of hoops that you have to go through. In the end, it's still a court order, but you're talking about an agency in a state that's trying to deal with an app that is out of state. But the bottom line is still all of that data that's on the phone, whether it's a file created, a file edited, a file deleted, that's on the phone. And that's where this evidence in this case was retrieved: deleted files and deleted text messages.
And there's a misunderstanding when there's someone deletes something or tells somebody to delete something that it's gone forever. That's not the case. It's going to wind up right in your hands.
So I describe it this way: is if you go down the street and you look at an address on a house and it's 8121 and you want to hide the house, so you just take off the numbers, the house is still there. That's what a deleted file is.
And by the way, digital evidence is key, because otherwise, a lot of times in these situations, you just have the word, maybe sometimes the word of the student against the teacher, and that may be sufficient. I'm sure in your experience, you might not have digital evidence, but you just have an account. In your experience, that might be sufficient to further an investigation or warrant charges, I imagine, but to have the digital evidence is going to be key.
Well, you bring up a great point. In this office and in agencies throughout the country, a confession is key. Is getting that individual to tell you, whether they're under Miranda or not, why they did what they did and what was the motive behind it. But in today's world, especially when you look at what's going on in the media world, in the entertainment world, jurors and prosecutors, defense attorneys, they want to see digital video evidence. They want to make sure that everything is uncovered. So in this particular case, was there surveillance cameras in the hallways of the schools? Was there surveillance cameras in the parking lot? Did anything happen in a particular part of the property? That digital evidence is all part of this pathway to get charges. And when it comes to the phone, we talked about that data being removed, but digital evidence is almost an expectation now in all criminal cases. where it's almost impossible to commit a crime and not have some digital evidence. And that's why law enforcement has upped their game to not only retrieve, surveillance footage, door cam footage, digital footage to add to the case, even on the most simple crimes, unlike this case.
Yeah, and I want to go back to the probable cause statement because despite Laughlin allegedly telling the student to delete the images off of his phone, police say the student had saved one photograph on Snapchat, which he showed to law enforcement. The statement reads, the student did have one photograph saved on his Snapchat account, which he was able to access through his cellular device. The photograph was displayed to me and showed a collage of pictures where one photo showed Laughlin exposing her breast. So after learning all of this, the officer then went to meet with Laughlin on the same day and talk with her prior to her arrest. But after reading her Miranda rights to her, Laughlin initially denied having an inappropriate relationship with the student, but according to the statement, she changed her story after a few minutes. The officer wrote, I informed Laughlin that there were allegations about her having an inappropriate relationship with a student. At first, Laughlin denied the allegations, but after a few minutes did tell me she was on Snapchat with the student, but he initiated the contact. So when investigators explained that the student was a minor and that sending or receiving explicit images involving a child is illegal, Laughlin apparently responded, I was not aware he was a minor until yesterday, so what happens? Now that statement notes that she did not deny receiving or sending the photographs, but claimed she hadn't requested them. I then explained to Laughlin the photographs that the student sent her were considered CSAM, child sexual abuse material. Laughlin stated to me she did not ask for those photographs. I informed her that receiving naked photos of children is illegal. Not once did Laughlin deny sending or receiving the photographs in question. At that point, Laughlin stopped answering questions, asked to speak with an attorney. The interview ended and she was placed under arrest. And according to the report, Laughlin gave written consent for investigators to search her cell phone, and that search revealed sexually provocative images of her corroborating the student's description of the content that was shared via Snapchat. Chris, is that a misunderstanding? You don't believe it? This idea, oh, he initiated it. I didn't realize he was a minor. That's not a defense, but I'm sure you've heard things like that before.
Oh, yeah. I mean, these are common responses when they're confronted with facts. It's mitigating, it's rationalizing, it's trying to create some distance. But what you just pointed out is key, is it's an admission nonetheless. If I said, hey, Jesse, I want to talk to you about this, and you had nothing to do with it, you'd be like, time out. I don't know what you're talking about, but that's not me. If you responded different by saying, well, what is it you want to talk about? Now you're in the door. That's how these confessions and these admissions kind of navigate through the path. And so when Laughlin was confronted with that accusation, the immediate truthful denial would be like, I don't know what you're talking about. That never happened. And you also watch their body language. But the digital evidence that was presented is probably the reason why she changed her story and said, well, I didn't know that until yesterday. That's an admission. And then what you do is you take that data that's on that picture with the statement that's taken in the probable cause statement or a confession, and that picture has a timestamp all the way down to the actual time zone. So you can corroborate what people are saying, or you can actually confront them if what they're saying doesn't match when the photo was received or sent.
It's a tricky dance trying to do an interview with a suspect, right, after Miranda rights are read. I mean, because there's always, a defense attorney will jump in and say, oh, whatever statements she made were coerced, they were manipulated. How do you balance that? What are the skills that you need in order to have a successful interview with a suspect where they provide you, answers and information?
So I think it's important for your viewers to know that there's a difference between an interview and an interrogation. An interview is me just calling you and say, hey, can you come to talk to me at the office? Or I'd like to come and talk to you at your house. You're not under arrest. You're free to come and go when you want. I can still take a confession under the interview umbrella. Because you're not in custody, I don't need to read your Miranda. And if you give me a confession, I can use that against you. But if I take your freedom away, or if I take you into a place where you are not free to leave, Miranda is required because it's now an interrogation. It just is the difference between not in custody and in custody. But the same motive of the investigator is to get a confession and to find out what are the details of this crime. So in this particular case, the detective went to the scene, her home, and gave her Miranda protection. And so there was no misunderstanding why he was there. And that's where he was able to solicit that. And then when she realized that she made some admissions, she says, I want my attorney. But that's what I think your viewers could actually, see the difference between an interview and an interrogation. Miranda is not used on all confessions, only when they're in custody.
I appreciate you making that distinction. And I have to tell you, how important is it for the victim in this case, children, to either speak to their parents or educators or friends? The idea of saving the Snapchat. There's so many times, how many times do we deal with cases where there is child sexual abuse and it's not revealed until years later? So the idea that he saved it is so significant, I think.
That is an example of where this victim's mindset was at the time. They knew something was not right. And they oftentimes think, am I doing something wrong? And that's why a lot of victims don't come forward, because they almost take on some type of responsibility when that's not the case. That's why they're a victim. And that's why we want to give them their voice. So this particular case, when he held that picture, it very well may be, I don't think people are going to believe me. So I want to make sure that I'm protected. And that's why when you take and in this case, a 16-year-old, they're only a 16-year-old brain. They don't have the maturity that we have to see and experience the things that we've experienced as adults. So it's not uncommon that a lot of times victims will keep something or write something down or tell somebody just to validate, hey, this happened and I need somebody to know about it, or I want to protect myself. And these plea deals also protect victims from having to testify and relive the whole scenario over, which results in the plea deals that we're talking right now. In this case, she got a great deal by escaping prison.
Let's talk about that, because when she was arrested, so she initially faced a series of egregious charges, including tampering or attempting to tamper with a victim in a felony prosecution, statutory rape in the second degree, sexual exploitation of a minor, tampering with physical evidence in a felony prosecution, furnishing pornographic material to a minor, and sexual trafficking of a child, second degree, under 18 years of age. Now, the case was transferred to Grundy County in 2024, and shockingly, Laughlin only ended up pleading guilty to one charge: endangering the welfare of a child, creating substantial risk in the first degree. No sexual conduct. On July 24th, 2025 is when this happened. She was sentenced to 5 years probation, no prison time. I have to ask you, Chris, again, going back to what we said before, I get it. I get the risks of going to trial. I get the complications of going to trial. No one wants to be exposed to this material, including a jury. You don't want to have the victim provide a statement or testify in any way. A lot of people are going to be looking at this and saying, I don't get it. What do you think? Have you seen something like this?
Yeah, I can tell you that. That's why plea deals are very difficult from an outside perspective to determine what all went into this deal. Maybe this victim's family said, we have lived enough of the trauma and the tragedy. Maybe they have some empathy for this teacher. Maybe the teacher was able to give more information on the case. There's a lot of details that most of us will never know. But a plea deal, especially in this case, is the end result of multiple conversations from victim advocates to the defense attorneys to the prosecutors. The judge has to ultimately look at that deal and determine, is this what I think is fair? So there's a lot of factors. What's sad is the trauma is one thing, but it's public perception, which is the reason why we're doing the story, is another thing. Because some of these cases can be used as deterrents for other people that are in that pipeline, whether it's a teacher or whether it's somebody in the faith-based community or whatever the profession is. And when you see deals like this, where you just mentioned those heavy charges, ultimately pleading to one and getting a 5-year probation, sometimes that sends a much lighter message, and it can water down some other cases. And it's used as a precedent too for defense attorneys. So it's a balancing act. I see this just like you do. They got a big deal, but there's probably a lot of things in the background that we don't know.
And to be fair, they might not have had a strong case. They might have felt they wouldn't be able to get a conviction on those higher charges. I will tell you, if you're dealing with this situation, someone not ending up on a sex offender registration list, does that bother you?
Well, that's, to me, the ultimate accountability, is if somebody did what she did, child sexual explicit material on their phone, underage, you had somebody who sent videos as an adult to a student, graphic videos. You had somebody who encouraged. She was definitely the aggressor. She was the predator. I mean, there has to be accountability long term. And when you have somebody that is, 26 years old, this wasn't, and I've always said this before, they're never caught the first time. How many other people could have been out there that we don't know about? So I have always been an advocate that if you're caught up in a crime like this, that sexual offender registry is key to hold you accountable. It's the only crime in the country that after you do your time, that you're still held accountable. And that's the power of that list and that registry.
Before I let you go, one more thing I wanted to ask you. So you have this Daily Mail article that was talking about Laughlin's punishment. It was quoting a Reddit user who claimed they were a classmate of the victim at St. James High School. Now, we don't know that for sure, but I'm just going to read you because I think it makes a larger point. They reportedly wrote, "What really got to me was how people reacted. When the student came back to school, everyone started congratulating him, praising him, and people on Snapchat are posting about how pretty she is and how lucky he was. That is absolutely disgusting." Now, Sheriff, I don't know if that's true. I don't know if people said that, but it doesn't matter. I'm sure this happens across the country. I'm sure that is a very unfortunate common reaction, no?
And that's the immaturity of that age group that sees it different than a crime. And that's the danger of this whole thing is you have somebody who's a predator that's seeking underage people who don't have the capacity to understand that this is not a joke, that this is not to be made fun of, that this is not to be held lightly. It's not something that you just joke about in a conversation. This is a crime in the making at a public school where other people are there. It'd be no different than any other crime. So that's the danger, again, of having a scenario of a teacher-student relationship, especially an underage student. But unfortunately, that pattern, and we look at other schools that have dealt with this throughout the country, that's how it happens, is these teachers, they build a relationship, they are the aggressor, and they don't stop. And then when the student is trying to deal with it, friends are brought in, and it just continues to spiral. Danger, danger, danger.
Genesee County Sheriff Chris Swanson, thank you so much for taking the time.
Thanks, Jesse. Appreciate you.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.